Like a large number of people, you may be putting off your estate planning. You may well think it's a boring topic, or you just may not like to contemplate your own passing, but the reality is that everyone will die, and you can either leave a painful mess or you can make sure your loved ones are looked after. Estate planning involves working out the best way to distribute your assets upon your death or the death of your partner. Planning provides peace of mind as you know that your affairs will be handled according to your wishes and ensuring that those that need to be taken care of are protected. As part of your estate plan, you will need to consider care and protection of children, ensuring that your will is actually valid, adequate life insurance, for business owners, implementing an appropriate business succession plan, the tax consequences of how your assets are distributed, superannuation death benefits, and enduring powers of attorney. You need to be aware that not all assets you control or own can be dealt with under your will, including assets that are owned as a joint tenant, assets owned by a company or held in trust, and superannuation death benefits, or even life insurance proceeds that are paid directly to a beneficiary rather than to your estate. A will is a legal document that sets out who is to receive your assets after you die, and it may also state your wishes regarding your funeral and burial, and appoint a guardian for any children you have who are under 18 years of age. The death of a parent would be a horrific time for a child, and nothing will be able to replace you, but you can make sure that they are going to be cared for and provided for financially. Estate planning can be very complicated when you or your partner have children from a previous relationship, as multiple family relationships need to be provided for. The potential for conflict when dealing with deceased estates is enormous, even more so if your estate planning is inadequate. If you die without a will, also known as dying intestate, your assets will be distributed according to the laws of the state or territory in which you lived at the time of your death. Dying intestate can also cause stress and expense for your family at an already difficult time. If you have children under 18 who are left without a parent and you don't have a valid will appointing a guardian for them, a guardian will be appointed under the laws of the state or territory in which they live. Your loved ones will be forced to deal with the courts, and the courts will control the decision-making process. You can leave a mess, leave your loved ones unprotected, and cause unnecessary tax and legal fees, or you can get your estate planning in order. It's a pretty easy decision. We can help take the stress and complications out of the estate planning process. If you are ready to proceed, simply contact our office and we can get started on your estate plan.